Hi, my name's Adam, this is All the News, and we're looking at some interesting stories today. This one is coming from Jezebel, also known as the man-hating feminists of the internet, and they've got some interesting stories today, which is all wrapped up in their man-hating and generally radical feminism. So what are they saying? Amber Heard's appeal lists 16 ways the court screwed her over in Johnny Depp defamation case. That's right, that's their perspective. The court did her over, and it's not her fault at all. She's an angel. Her attorney, she's not. Her attorneys argued that if the ruling stands, it undoubtedly will have a chilling effect on other women who wish to speak about abuse involving powerful men or just men. That's what we like to call a slippery slope argument or a policy argument. What they're saying is that if the court doesn't overturn the decision, then this policy will affect people in the future. However, this isn't the role or the job of the judiciary. That's the job of the legislators, the people who make laws. The job of the judiciary is to interpret the law, not to concern itself with what happens with the law. That is down to the legislature. So these slippery slope arguments don't really hold weight, and all they do is tell the court that you don't have any legal rights, you don't have any legal facts, you don't have any proper law to tell them. All you can do is point to slippery slope arguments and say, well, if this stands, then people will have a problem in the future. It's not good enough. It's not how law works. So let's have a little look at their other shenanigans that they've got going on. So we've got the Sea Witch and we've got Johnny Depp in his lingerie at the Savage by Fenty show. I still like this thing. When it comes to yet another legal update in the sordid saga that is Johnny Depp and the Sea Witch Virginia defamation trial, I know what you're thinking. Here we go again. That's right. As someone who's been there to document every court filing, callous social media response, and gummy bear gobble, I hear you. Unfortunately, it does continue. You keep putting it on your website, and you keep having clicks, and you keep wanting people to come back. So hush. In the last month, both Johnny Depp and Amber Heard have sought to appeal the verdicts, which concluded both parties had defamed each other. Yeah, that's putting it in a weird way. Johnny Depp comprehensively won millions and millions of dollars, and she was punished with a $5 million punitive fine. To try and claim that they both defamed each other, I would say is disingenuous at best, and I would say is deliberately trying to mischaracterize the reality at worst. So there you go. Amber Heard via her Washington Post op-ed, exactly, and Johnny Depp via a statement from his attorney that argues he shouldn't be held accountable for defaming her. Right, that bit sounds completely wrong to me. He was found liable for a statement made by Adam Waldman, which is his attorney, but that statement was a statement that said he believed, as in Adam Waldman believed, that Amber Heard and her friends roughed up the building in order to set up a situation for the police to find. That isn't what this sentence says, though. Argues he shouldn't be held accountable for defaming her. That's not what happened at all. So yeah, again, either mischaracterization at best or deliberately trying to deceive. Hey, Jezebel, don't worry about facts. Oh, Jezebel is a Latin word. It means people who don't care about the truth. That's what that is up there. And yeah, that's what that is. Heard's appeal, there it is, filed by her new representation, David L. Axelrod. I still think he should be in a 1980s hair metal band, maybe with Poison or something. And J. Ward Brown, not as interesting, of Ballard Spahar, a firm specialising in constitutional law, is aptly leaning all the way into First Amendment arguments. It reminds me of a YouTube video which is called Movie Pitch, and he keeps he's got a catchphrase where he says, you're going to have to get all the way off my back about this. So we've got David L. Axelrod, J. Ward Brown, and they're leaning all the way in to First Amendment arguments and excoriating, such a lovely word that one, the actions of Judge Penny as correct. I can't pronounce her last name. After Depp filed this case, the United Kingdom High Court of Justice, we're going back to that one, are we, ruled in a separate defamation action brought by Depp that Amber Heard's abuse allegations were true. The 68-page document reads, the trial court should have given preclusive effect to that 129-page decision. I had to look up the word preclusive. I haven't heard anyone say such a thing for a long time. And I was like, preclusive? What is that? Preclusive, preventing something from happening, restrictive. Right. Okay. So the trial court should have given a restrictive effect to that 129-page decision, which followed a 3-week trial in which Depp heard and 24 other witnesses testified. Yes. So you're trying to use a trial in a different country with different parties, with a different standard of proof, with different witnesses, and you're saying that should stand, and that should be what we stick to, even though it's completely different parties in a completely different jurisdiction under different laws, and that's good enough for you. Well, no, basically, no. Can't be going with that one. The filing's broad argument is that this case shouldn't have gone to trial at all. The document details 16 specific court errors. This is another problem. If your main argument is the case shouldn't have been brought to trial, all you're telling the appeal court is we're trying to avoid the trial. We would have lost, so we're trying to avoid the trial. It shouldn't have happened at all. We shouldn't have gone to court. We should have used some trick, some manipulation to not go to court, because if we went to court, we would have lost, and they did lose. So this isn't a strong argument. All you're saying to the appeal court is we wanted to weasel out of it. That's the opposite of what you should be telling an appeal court. You should be saying we're desperate for this trial to go ahead. We're desperate to prove our case. We're so confident. We're so powerful in our case. We're so secure. We would have done the trial twice, rather than say it shouldn't have gone to trial. Is there any way we can weasel out of it? And the appeal court's going to go, no. No. I did do a lot of appeal stuff when I was at university doing law. I was Master of Moots and Competitions. I won the university legal debating team with my partner, Kyle. So I'm quite good at this sort of stuff. And I was taught by a very good teacher about this sort of concept of strength of argument and what you should be saying to the appeal court and what you shouldn't be saying to the appeal court. But saying to the appeal court, it would have been really nice if we didn't go to court because we'd lose, is an awful argument. It's just terrible. But let's move on. The document details 16 specific court errors. Again, this is not a good thing to do. You're throwing out a shotgun effect, trying to capture as many things as possible in the hopes of one of them sticking. The problem with that is an appeal court needs a significant and real evidentially based fact. They need reality to point to, because they're going to overturn a jury verdict. And you can't just say somebody forgot to put the T over the I's and somebody forgot to put the document in the box. It's got to be serious. And so chucking out as many things as you can find isn't good enough. So let's have a little look at their facts. They're facts that they've got. Facts. The venue of the trial is among the weightiest. Not good enough. Not good enough at all. None of the conduct relevant to Depp's defamation claims occurred in Virginia. Doesn't matter. He's a global celebrity. The document reads, Depp is a resident of California. The damages done to him were global. Doesn't really matter. The incidents that led to Heard obtaining the restraining order took place in California, not Virginia. But that doesn't relate to the defamation statement made in the op-ed. Virginia, the attorneys argue, is a wholly inconvenient forum with no connection to Depp or any meaningful connection to his claims, apart from the Washington Post servers are actually there. The document also contends that it played a significant role in why few people were able to testify on Heard's behalf. Really? Everyone else seems to manage. Numerous courts interpreting Virginia law have concluded that the place of the wrong for interstate defamation claims is where plaintiff incurs the greatest reputational injury. We're talking about Johnny Depp here. So he was damaged on a global level. People in the UK, like my good self, heard about it. And so it isn't the 18th century. This is not the Victorian period where everybody lived in their nation and in their state and never left their state. This is Johnny Depp. He flies on a plane to Paris yesterday. He goes off to Vancouver tomorrow. He's in, pick a country. He's there next week. He's global. The damage done to him was global. It's irrelevant. Moving on. Just moving on. Home state. What is this? The Victorian period? Are we still driving horse and buggy around? It's ridiculous. Oh, and when we go back to this slight little bit up here, why is it difficult for other people? Inconvenient for them? significant role in why few people were able to testify on Heard's behalf. You can have video link. Everybody's got a phone. All you need is a phone. Your friends can't have a phone. They couldn't borrow a phone. You couldn't stick them in front of a phone with a camera. Really? Really, Amber? I very much doubt that. I very much doubt. Other people managed to do it by video call. Someone called in from a car. Someone, who else was it? Kate Moss, she was on video. This is just spurious. And again, I would say a mischaracterization at best and an attempt to deceive at worst. Moving on. Because of his choice of location, Heard suffered substantial prejudice given that her former team were not able to subpoena witnesses to testify on her behalf. In what way? In what way? There's no substantial prejudice. You could have easily got them on the video call. Video calls were allowed. I mean, there's literally nothing there. And you couldn't afford to get them on a plane? I find that very difficult to believe. What I find reasonable to believe is nobody wanted to. Nobody wanted to turn up on your behalf. Maybe. Hey? Hey? Looking at you. Yeah, that's right. Looking at you. AH's attorneys directly referenced the statement made in court by Depp's attorney, the legendary Camille Vasquez. You may have noticed, we did indeed, no one showed up for Ms. Heard in this courtroom other than her sister. Yeah, we did notice that indeed. Yeah, we did. Other than a witness who travelled to Virginia for her as a paid expert. This is a woman who burns bridges. Her close friends don't show up for her. There you go. Because she hasn't got any close friends. Because she's stabbing them in the back as soon as look at them. But even if you do have people, all you had to do was put them in front of a video camera. And the judge would have been perfectly happy with that. So, no, basically, no. AH, the attorney's gone to note, wrote the op-ed in California before sending it to the ACLU in New York. The ACLU then gave the op-ed to the Washington Post, which published it online. Sort of, yes. Amber wrote it under direction from the ACLU and then sent it to the ACLU, who sent it back and revised it and sent it back and revised it, and she revised it. Multiple editions, backwards, forwards. Then they give it to the op-ed to the Washington Post. Then they publish it online. So yeah, okay. The client, they allege, never actually had contact with any Washington Post employee. What's that got to do with anything? I mean, in what way has that got to do with anything? What's that to do with the price of onions? Nobody knows. Nor had she stepped foot in the state of Virginia, but the servers of this organisation are there. And it's irrelevant. And even if it was, all you're trying to do is move the location to a place where the SLAPP law or legislation exists. And that, again, is an attempt to stop the trial from happening. And you're trying to stop the trial from happening because your case is so weak and you'll lose. And that tells an appeal court that you're trying to weasel out of it. And it's not good. It's just not good. You need to exude strength. Sun Tzu's Art of War. Read Sun Tzu's Art of War. It's much more useful than you'd think. And what else is going on? Nor had she stepped in the state of Virginia, irrelevant, making it all the more befuddling why the case would be heard in that state, while trying to avoid the SLAPP legislation. Other errors include the exclusion of key evidence, hearsay, supporting Heard's abuse claims, namely any mention of the UK trial verdict. This is a different jurisdiction. It's a different trial with different parties. I mean, what are you going to do? You're going to bring up the Keishin Kaisen Kawasaki case? I mean, which cases do you want? You want to bring up high trees? Which one do you want? Pick a case and you're going to bring that in? You can't just randomly pick a case. It's the wrong parties and it's the wrong jurisdiction. They're two different things. UK jurisdiction is actually split into three. We have England and Wales, which is one section, Scotland, which is another section, and then we've got Ireland as another section, none of which is related to US legislation, completely different thing entirely. So no, not at all. So what else we got here? Any mention of UK trial verdict, Depp had in fact abused AH on 12 occasions, damning text messages that seemingly confirm abuse had occurred, including that of Stephen Dutas, Depp's former assistant. I haven't seen these text messages, and even if I had, they're text messages and not reality. What you say on our text message is one thing, and what actually happens is quite another. And no, different jurisdiction. For those who have been paying attention, I have been paying attention, unlike your good self, Jezebel. Well, it's a Latin word. It means man-hating radical feminist. That's what it means, which is quite interesting. So for those who have been paying attention, like my good self, both AH and Johnny Depp's appeals are entirely predictable. Yes, they are actually. They are. I can see where they're going. And in AH's case, justifiable. No. Mischaracterization at best. In the immediate aftermath, I spoke to Virginia defamation attorney. Wow, okay. About the host of legal head scratches. There's a phrase within the trial. Specifically, how proceedings that were intended to examine a singular op-ed that never directly alleged any variation of abuse devolved into a full-blown domestic abuse trial. Okay, why? This issue is to do with defamation itself. If you make a statement that is bad about someone or, nasty, if it's true, it is de facto not defamatory, because truth means it's not defamatory. So this whole case revolved around, was it true or was it not? And for Amber Heard, her relationship with the truth is not a good one. I mean, they are estranged. Truth and Amber Heard have not met each other for a long time. Truth went out for a packet of cigarettes and didn't come back. That's what I'm saying with Amber Heard. She is not a good friend with Truth. And that's the problem. That in a defamation case, anything that is a statement that is bad, nasty, or awful about someone is not defamatory if it's true. That's the key principle I want to say here. And that is, that's fact. That is legal fact. I can give you the case law for that all day long. And that is why it comes down to looking at the whole case. The whole trial, for the most part, came across to most people, I believe, as a question of which of these two sides is the real abuser. Amber Heard. Lee E. Burlick, is that the name you're going with? Okay. Told Jezebel via phone interview in June. Jezebel is Latin for a person who does not worry about the truth. By a phone interview in June. Who is the better spouse? Johnny Depp. Who is the worst spouse? Amber Heard. Do we believe Johnny? Yes. Or Amber? No. Whose side are you on? Johnny Depp. But these are quite easy. More difficult questions, please. But really, that's not what this case was supposed to be about. Yes, it is. It's a defamation case, so it is about who's telling the truth. Additionally, Burlick highlighted the fact that the op-ed didn't specifically mention Depp. Irrelevant. That's defamation by implication. Or anything that may or may not have transpired at the time of their relationship in 2016. Highlight the fact the op-ed didn't specifically mention Depp or anything that may or may not have happened. It's still defamation by implication, because she said she's a representative of domestic abuse. That's clearly an implication that he's a domestic abuser. And so that's fine. This whole case and a lot of the evidence tended to be all the details of what she apparently claimed back in 2016. Again, it's who's telling the truth, and nobody believed AH. The bottom line of AH's appeal, let's have a look at what their actual key point is, that holding, if allowed to stand, undoubtedly will have a chilling effect. Slippery slope argument. Not good enough, my friend. Not good enough at all. That holding, if allowed to stand, will have a chilling effect on other women. You see, this is a moral argument. It's you're asking the courts to turn into moral arbiters, as if they are the people who should guide society in a certain direction. And it's not the job of the judiciary to do that. It really isn't. That's the job of the legislature, the people who make the laws. They're the ones who are meant to guide society in the direction they want. If everybody in society suddenly decided tomorrow that theft was fantastic, then within 2 weeks, theft would be lawful and encouraged by the legislature. They would put forward laws about theft being a great thing, because morality changed and legislature goes with morality. The judiciary only interpret the law that they get from the legislature. That's all they do. They're not there to be moral guardians, and they shouldn't be. When they start doing that, it's called judicial activism, and it's frowned on, because it's not their job. That's the job of the legislature. It's a principle established by Montesquieu, Baron de Secondat de la Brede de la Montesquieu. He said there was 3 powers: the legislature, the executive, and the judiciary. They had to be separated. These 3 things, these 3 powers, things that had power, have to be kept separate, otherwise they corrupt each other or become corrupted. So we have to separate them, and they have their own spheres of influence. The legislature make laws. They vote and make laws. The judiciary are judges and they apply the laws. And the executive is the president or the prime minister or the person who makes the guiding decisions, the leader. And he has a team and they're called the executive. So these three groups have got to separate each other. And that's what Baron de Seconda de la Montesquieu said. The separation of powers. And that's what this is about. Judges have one thing. The legislature have another thing. Executive has another thing. So, yeah, from what I'm reading of this appeal, it's appalling, and they're going to lose badly. For you today, let me know your thoughts, your hopes, your dreams, your ambitions, and leave a like and a comment if you liked anything. Subscribe if you haven't already, that'd be fantastic. Join the membership, press all the buttons, press everything. If you find any buttons, press the buttons. And yeah, come join the channel. It's mostly about either Johnny Depp or fashion at the moment. I don't know why, it just is. And I will see you guys later.